A very good morning to everyone on the platform this morning. Let me take the opportunity to welcome you officially to our meeting this morning. My name is Moonilal Lalchan. I'm the Procurement Regulator and Chairman of the Board at the OPR. I have with me this morning Maurissa de la Rosa. She's the Head of Capacity Development, and my Executive Assistant, Stacia Mabia. So this morning is really a privilege to share with the Children's Authority, and we will go right into our presentation. Just for the records, we are recording the session this morning so that if any member of your organization is not able to attend, you will be free to download the recording and share it with as many people as possible after the session. Additionally, we will also share the presentation, the PowerPoint presentation with you after the session so that you can use the PowerPoint presentation as you see fit. There is no copyright issues associated with it. And just for good order, we will wish that everybody mute your microphones so that the quality will be preserved. And if we do have any questions, we will take those questions at the end of the presentation and have as many of those questions answered and have it as interactive as possible. So here we go. I will be doing the first part of the presentation, and then midway through, Maurissa will take over from me, and at the end, she will answer all the questions. Just kidding, we'll both answer the questions. All right, so why procurement legislation? Why we had to make all this fuss, upset the apple cart, change things as we are accustomed doing it? So there are a couple of data points in setting the context this morning that we wish to draw your attention to. And one of it was a study was done by the OECD, Organization for Economic Cooperation and Development. And they did a report in 2014, and they confirmed that public procurement is one of the government's activities most vulnerable to corruption. And it was done internationally. And what they suggested in that study is that 2/3 of foreign bribery cases occurred in sectors that are closely associated with contracts or licensing through public procurement. If done correctly, you can save between 10 and 30% of the investment in these projects. So what we did is a very quick calculation, and if our budget is about $52 billion per year in Trinidad, and half of that, 26 billion, is spent on procurement activities. And our information is that it might be more than that, because when you take into consideration the expenditure, both capital and operating, by like the big companies, Heritage Petroleum, NGC, Caribbean Airlines, National Flour Mills, Clip Deco, and a whole host of others, it tends to go upward of that, because this really looks at what is being considered under transfers and subsidies and so on. So if we say 20%, midway between 10 and 30% could be saved, literally we are looking at about $5.2 billion per year that potentially can be savings. And think about what we can do with that 5.2 billion in terms of medical, road constructions and repair, water and sewage authority, etc., etc. So that's one of the data points. The second one is that a study was also done by the European Commission, and they suggested in the European Commission, not the Caribbean, this is where you have all these big countries scoring very high in the corruption perception index. So they're supposed to be among the best, but they lose euro $120 billion every year. And similar type of percentage between 20 and 25% could literally be saved if done correctly. And a big portion of that has to do with how you manage the procurement activities because of the lack of capability within the sector. And about 50%, that big blue half of the pie chart, could be saved if you have proper management of the function. So again, there is a significant amount of monies that can be saved if you do things right. And then there are two additional pieces of information we want to bring to the fore, and this comes closer to home in Trinidad, where the Honorable Prime Minister, in his address to permanent secretaries and heads of the departments, suggested in January of this year that the public sector, once becoming digitized, it would reduce the corruption and make it easier to track the level of corruption that's taking place in the public service. Later on this year also, there was a statement by the Archbishop that says there is corruption widely practiced in Trinidad from top to bottom, and it's endemic in our society. This was just done about 3-4 weeks ago. So here you have 4 different areas of context setting as to why we really need public procurement legislation and effective legislation at that. So then came the Public Procurement and Disposal of Public Property Act 1 of 2015. And this act seeks to provide for public procurement and the retention and disposal of public property. So it's not only about procurement, but retention and disposal of public property. And this should be in accordance with good governance, namely accountability, transparency, integrity, and value for money. And with the passage of this and the full implementation of the Act through full proclamation, the Central Tenders Board Act 71 of 91 and related matters will be no longer in existence. So all public bodies now have to do their own procurement and disposal activities in accordance with Act 1 of 2015. So who is the OPR that was established under the Act? It's a regulatory body governed by an independent board appointed by the President after consultation with the Prime Minister and the Leader of the Opposition. And the first board was appointed on January 12, 2018. And since then, the board has settled down to work and put all the different mechanisms in place to ensure full compliance. And once we have full proclamation, we'll be up and running. The office shall not be subject to the direction or control of any other person or authority in the performance of its function, but shall be an independent organization and accountable only to Parliament. Who are the public bodies under Section 4 of the Act that are required to follow what is required under the new regime? It's the Office of the President, and that's the President of the country, the Parliament, the Judiciary, all ministries or department or division of ministries, the Tobago House of Assembly, or any division of the Tobago House of Assembly, municipal corporations, regional health authorities, statutory bodies, state-controlled enterprises, and service commissions. So you see, it's really very wide and encompassing. But if you do not fall under any one of the previous that I mentioned, you are also required to follow the Act as a public body if you are body corporate or unincorporated entity using public money. Very important definition. And public money means money that is received or receivable by a public body, raised by an instrument from which it can be reasonably inferred that the state, Trinidad and Tobago, accepts ultimate liability in the case of default. It is spent or committed for future expenditure by a public body or distributed by a public body to a person. This one is extremely important. For example, all the sporting organization that gets funding from the Ministry of Sports and Sports Company of Trinidad and Tobago, they are considered to be public body because they are in receipt of public money, or raised in accordance with a written law for a public purpose, or appropriated by Parliament under the national budget. If there is an appropriation by Parliament to any organization, you are a public body. So what are we about? What is required in terms of fulfilling the objects of the Act under Section 5? Section 5 mentions a number of things. You would see in the preamble to the Act, it mentions to promote the principles of accountability, integrity, transparency, and value for money. But Section 5 actually goes a little deeper and more broadly in terms of dealing with the whole issue of efficiency, fairness, equity, public confidence, local industry development, sustainable procurement, and sustainable development. So recently you would have seen a lot of talk about sustainable development, how you do things from a sustainable procurement area. And then here comes local industry development. So a lot of these principles now will be embedded in your practices from day to day. What are the functions of the OPR? What are we supposed to do as an organization? We are to establish a comprehensive database of information on public procurement and tenders received, awarded, and values of contracts. So that system has already been established and it's functional. We haven't opened it for the public yet, waiting for full proclamation, and a number of these are required under the full proclamation. What the public body will be required to do is on a quarterly basis, 3 weeks after the end of the quarter, you are to publish all tenders received, awarded, the value of the contracts awarded, and to whom it was awarded. So that has to be done on every quarter by the 3rd week after the quarter. For example, by the end of March, you are supposed to do it by the 21st of April. We are supposed to set training standards, competency levels, and certification requirements to promote best practice in procurement. That has already been completed. Maurissa is head of that team. And you can find that certification standards and requirements on our portal if you log on to OPR website. To issue and review guidelines in relation to public procurement and the retention and disposal of public property. All public bodies now either have to follow the procurement guidelines and handbooks that we have established, and we have established 44 of those so far. We just about going to launch another 2, which will bring it up to 46. So you either follow those procurement handbooks and guidelines, or you develop your own. But once you develop your own, you'll have to come back to the office and have it approved by the regulator before you undertake those activities in terms of procurement and disposal. And that was to prepare and update issue model handbooks, etc., to approve in respect of each procurement entity special guidelines. So I just mentioned those 2 together. To promote the use of technology in public procurement, so you have a lot of technology now, reverse auction, forward auction, e-procurement, EGP, electronic government procurement, all those now will be promoting. Not that we will be putting in place the EGP, but we will be encouraging it, and hopefully one of the ministries will just take it over and establish an e-procurement system that the rest of ministries and organizations can benefit from. We will be promoting best practice, and so far we have given advice to over 1,000 requests for information and help in terms of the conduct of procurement and disposal activities. To harmonize policy systems and practices, what we found when we took up office is that as many as you have public bodies, you have different practices. So for example, in a regional corporation, regional health authorities, they would have different practices, even though their business is very similar. So we have established these policies and systems, so there will be unanimous approval across different spectrum of different organizations. So that will create some synergies and also allow for better communication, and you can pool your resources to better get better pricing and better value for money as required under the objects of the Act. to review procurement practices and delivery system. This is about continuous improvement. And it may not only be on an annual basis, but it might be even more frequently than that when we find that there are areas that we could benefit from to improve the practices. To maintain and update related systems-wise database and technology, we have put together all the technology and databases that is required under the Act, including the depository to register contractors and suppliers. And we have also developed a learning management system that Maurissa will highlight later on in the presentation. And to promote the awareness of public bodies and public to issues relating to public procurement, so far, this session here is the 311th session that we have had so far. So we have already had 310 public awareness sessions that have already gone. And of course, to undertake research and surveys with respect to public procurement, again, to gauge the market and see what's happening. We have done a number of those surveys already. You would see this area here in red. When we took up office, we thought that at the OPR, this is going to be a conflict of interest if we were involved in actually disposing of real property and having to come back and audit that same disposal. So we approached the government to remove that from under the purview of active involvement of the OPR, place it under another ministry that allows us freedom to go in and audit the process. So we'll be involved in actually developing the guidelines and handbooks as part of that process together with the government, and then give us the wide-ranging audit and investigative powers to deal with that. So that you would see is no longer in the Act. To create and publish standard form contracts, we have already started that process, and we have already issued some of the standard contracts, form of contracts on a case-by-case basis. And to maintain database of pre-qualified contractors and suppliers, so far we have over 1,000 suppliers already listed and come onto the database to be pre-qualified. We have not formally pre-qualified them, and this will be done once we have full proclamation. We have also had 16 public bodies like yourself already come onto the system and put in their line of business. So there will be a match between the suppliers and contractors and the public bodies. And we also have to prepare and maintain a list of pre-qualified mediators, arbitrators, and experts. And the reason for this is that before things get out of hand and go to the courts themselves, the Act provides for mediation and arbitration to resolve issues, thus saving the participants in those exercises a significant amount of legal fees and court time and so on. And to provide advice and best practice to obtain value for money. That is something that is important. For example, many a times we would buy very expensive pieces of equipment and run them to failure without having proper maintenance contract in place. It is required now that you have to secure your asset, make sure you maintain it in a fit for purpose mode, and also make sure that you have different things in place like maintenance contract, warranty periods, and so on. Similarly, for when you put down these very expensive buildings, you need to maintain it and make sure that you keep the value up so that you'll be able to tick that box of obtaining value for money on your assets. The last two of these, under the Act, we have audit review powers that we can check to ensure compliance with the objects of the Act. So we do have an audit and investigation team on board, fully briefed and ready to go. And we can investigate on our own initiative or upon complaint from any party involved in public procurement and disposal or any member of the public, any alleged or suspected breach of the Act, and we will be investigating those and take the necessary action as we see fit under the Act. So what are some of, I know we have some board members on the session this morning. What are some of the roles and responsibility of the boards, and how do we achieve the separation from the board and management in terms of the public procurement and disposal activities? Under Section 99 of the Companies Act, it states that every director and officer of a company shall exercising his or her powers and discharging their duties act honestly and in good faith with a view to the best interests of the company and exercise the care and diligence and skill that a reasonably prudent person would exercise in comparable circumstances. So you must be able to achieve those. Additionally, in the SEMP manual, and that is the State Enterprise Monitoring Manual, Section 2.26, the Board of Directors under the Companies Act 1995 directs the management of the business and the affairs of the company. And the board must not usurp the authority on the responsibility of executive management by involving itself in day-to-day management activities and issues. It's an organ of review, appraisal, and appeal. So procurement and disposal activities is viewed as a day-to-day management issue and operational issues, not governance necessarily. And the board of the company performs a specific set of functions to meet the mission of the company in terms of planning, monitoring, and controlling the activities, and to ensure that the resources are utilized in the best interests of the organization. They are involved in the development of policies and are also required that business decisions taken at the board level are implemented. So all the policies, handbooks, and guidelines that you will be accepting or adopting should be reviewed and approved at the board level. And the board should also be thoroughly familiar with the company and its various publics in order to serve them effectively. And this will include things like the suppliers and contractors that you engage from a day-to-day basis. You are to ensure that the company is staffed by competent senior management personnel, set standards, and review managerial performance. So setting the standards will require, for example, that you make sure that your annual procurement plan is in place and published within 6 weeks of the passage of the national budget. So you are aware and you have to approve those annual procurement plan. That way you are aware of all the procurement activities and disposal activities that will be coming for the next 12 months, and you can monitor it. And we are suggesting very strongly that management keep the board informed in terms of what takes place on a month-to-month basis or quarterly, depending on how often the board meets, so that you get a report of the procurement activities and also disposal activities, so you can raise any pertinent questions in keeping with the plans that you would have approved previously. What we also did was to scan the Exchequer and Audit Act in terms of the accountabilities of accounting officers. And it says that the accounting officer shall be responsible for ensuring that the financial business of the state for which he or she is responsible is properly conducted and public funds to their care properly safeguarded and applied only to the purposes intended by Parliament. And that's where the annual procurement plan comes in, because it forms part of what is required for you to submit to get your funding from government. All accounting officers are personally and pecuniarily responsible for due performance of the financial duties and the proper collection and custody of all public money receivable by them. And also to make sure that everything is accounted for when the Auditor General comes in to do their audit. So even though you are the accounting officer, you are not absolved from responsibility for complying and securing compliance with the Act, regulations, and instructions given to you. And the scope of the authority by reason of the responsibility of the Auditor General to check and report any shortcomings in connection. So you're still required to keep copious accounts and get it audited by the Auditor General or auditor required to do the statutory audits. In some cases, the AG, Auditor General, does not have the capacity to deal with all the public bodies. So when you appoint your own auditors, you are still making sure that you have that responsibility to comply with the Act. You shall not be relieved from responsibility for an act which is required by the Act or any instructions to perform if you have redelegated that to another officer that is subordinate to yourself as the accounting officer, and you shall be answerable to the Public Accounts Committee, etc. And then we looked at the responsibility under the Public Procurement Act. And under Section 61(2), it specifically says, and this is extremely important, and you would have seen a lot of this on the news, for the purpose of this act, a public body like yourself shall have a procurement officer who shall be responsible for public procurement and the disposal of public property for that body. And I went through the requirements of the board and management and so on previously, so that this will sink in a little bit more. And you shall notify the office in writing of the name and designation of the procurement officer. So the procurement officer is the one responsible for the day-to-day operational aspect of procurement and disposal of public property. And therefore, the role should not be taken lightly. And you don't just appoint any and anyone to fulfill that role. The person must be properly trained and also certified to carry out the function, depending on the level of complexity of your procurement and disposal activity. A reference to the act of the commission of an offense by a public body shall be construed as a reference to the commission of the offense by the procurement officer or anyone who purports to act in such a capacity. And if the offense was committed with his direct consent or connivance, or he with knowledge did not exercise reasonable diligence to prevent the commission of the offense. So any officer from the board of directors come down who puts themselves in the position of the procurement officer to do things to influence that procurement activities and so on could be held liable under the act and could be charged with the offenses. For the first time now, under regulations, tying back it with the Act, Part 9 of the Public Procurement and Disposal of Public Property, Methods and Procedures Regulations, clearly states that a procuring entity shall establish a Procurement and Disposal Advisory Committee. And this committee should constitute, for example, like the head of legal, corporate secretary, head of finance, subject matter expert, and such other members as may be necessary. Why do we need a PDAC? Because of the importance of that role, we need like the head of legal, head of finance, and so on to be functioning within that role. And of course, you must have alternates so that if they are conflicted or they are sick, they're on leave, out of the country, you will have other persons that fill the role so that the work of that committee is not stopped. And it continues. The committee can actually source members from other public bodies if you don't have it within the establishment. Of course, you will have to appoint a secretary to the committee to attend the meetings and take notes, but that person should not be a voting member of the committee. The role of the committee is to review reports, recommendations for contracts award and procurement proceedings and property disposal files. So the PDAC is not an authorizing body. So they make recommendation. They look to make sure that there is adherence to the Act and regulations, handbooks and guidelines, procurement and disposal strategy, and to make sure you achieve the objects of the Act under Section 5. Where the committee is of the opinion that there is not adherence to the achievements as set out in Sub-Regulation 5 above, they shall recommend the appropriate action to the procurement officer and explain that in writing to the accounting officer. Where there is an agreement, the committee shall give the accounting officer a written recommendation, which must be accompanied by the procurement proceeding files and the disposal file. Any member of the committee shall disclose any conflict so that to make sure that they are not conflicted, because if you are conflicted, you're supposed to recuse yourself. If you're a member, director, or shareholder of a company doing the necessary tender, you're a proprietor or partner, is employed by or is otherwise party to the contract, has a financial interest or a relative with a financial interest, and is a relative of an individual being reviewed by the committee, and all those are defined. So this is a diagram that we like to share in terms of how all this fits together. On the top left-hand corner, you have the disposal committee. Top right-hand corner, the evaluation committee. So one deals with, on the left-hand side, disposal activities. And on the right-hand side, evaluation committee deals with procurement activities. They all come together at different stages. They do their work, they evaluate, make recommendation, and that recommendation goes to the named procurement officer. In some cases, the named procurement officer will be intimately involved in those activities, so they are fully aware of what's taking place. The named procurement officer then does the recommendation to the PDAC. PDAC reviews in keeping with the requirements of the regs. They make the recommendation to the accounting officer or equivalent. So it could be a managing director, CEO, president, etc. The accounting officer or equivalent now says, okay, I'm happy with your recommendation for disposal on the left-hand side. I go ahead and execute and make sure that it's done in accordance with the recommendation. If they are not happy with that recommendation, they can either go back up the ladder or go to the minister with line responsibility. And between the accounting officer and the minister with line ministry authority, and this is under the Act, they can make the arrangement to disposal of the stores and equipment in keeping with whatever they agree with. But once that is done, notes must be kept on the file and notified to the office, the accounting officer, and also the named procurement officer. For high risk, high value disposal, you may always want to keep your board of directors involved in terms of keeping them up to date and having a no objection. Approval is not the word, but no objection. So what you do, you take it to them and say, we are going to dispose of this. We know you wanted to be aware of it. Do you have any concerns? If you don't, we go ahead. If you have concern, please state it and the reasons thereof, and we put it on the file and then investigate, or they can cause to be investigated by the audit committee of the board. On the other hand, on the right-hand side for procurement, if you accept the recommendation, you go ahead and you go and procure the activity, the items. Of course, for high risk, high value areas, you keep your board informed. And you do not have any recourse to any line minister in terms of procurement, only on disposal activities. So where you believe that everything is okay, you go ahead and execute. If you don't believe it's okay, you can ask your audit committee to have a look at it. And once okay, then you release and you procure the relevant goods, works, and services. In any event, if you're not happy with it and you think something is funny, you send it back up the line to the named procurement officer and you have it reviewed. And once you're satisfied, then you execute. One of the things you would have noticed is that there is no involvement in any outside parties here. Everything is done within the organization. So it should be less bureaucratic. You don't have to go board of survey to dispose. You don't have to go central tenders board for everything over $1 million. So everything now is within the hands of the organization. And that's a big, big free up in terms of time and resources. You just need to make sure you follow proper procedures. Under Section 6(1) of the Act, any procurement of goods, works or services, or retention and disposal of public property that is not done in accordance with the Act shall be void and illegal. And of course, in making those things void and illegal, we will exercise the necessary function that the office has in making sure that we take the necessary step to minimize any negative economic impact arising out of the performance of our functions. And we have already established those protocols to be followed and so on. I would have mentioned under Section 27(1), within 6 weeks after the approval of the national budget, We will publish on our website. You will publish on your website or any other electronic format all your planned procurement activities. The key word here is all planned procurement activities for the following 12 months. You are required also to update the information referred to as necessary based on major changes to your plan and the portfolio. And if any member of the public wishes to get a copy of that and they don't see it on your website or other electronic format, they can request a copy and you are bound by law to give them a copy. Charge them a fee, whether it's the cost of printing or production through the photocopying machine and so on. If you fail to do that, they can make a request to the office to have you give them that copy, and we will take the necessary steps after an investigation to decide how we proceed further. We would have mentioned the Procurement Depository. So what exactly is the Procurement Depository? We are required to establish this database to be known as the Procurement Depository under Section 26(1), to which all suppliers or contractors can submit information with respect to, among other things, their qualification and experience. So we have developed this depository. As I mentioned, over 1,000 suppliers have already come in. How it works is that they come in and they put in all the information that is required under the depository. Then they select the line of business, and every line of business to be pre-qualified under has a code. And we have established that code through the UNSPSC code, which is an internationally accepted code of business. And once they have put in their line of business, we then require the public body to go onto the system through their named procurement officer or delegate and put in the line of business that they will be having to secure for procurement for the next 12 months. So you put in your line of business as a public body. Suppliers and contractors put in their line of business. With the value category, there are different value categories. Up to 100,000, 100,000 to 2 million, 2 million to 10 million, 10 million to 25 million, 25 million to 100 million, and then 100 million and above. Once you do that, the supplier and contractor could indicate, well, Children's Authority is one of the organizations we deal with. If they put in Children's Authority, it is automatically routed to the person in Children's Authority to look at the application. And they review it, and once everything is okay, they tick the box and you are pre-qualified. So that's how it works in principle. If you don't have an existing business relationship with a public body, there is a match that is done by the UNSPSC code and is routed to the public body. Once you pre-qualify the supplier and contractor, they are now visible to all public bodies, not only the public body that has pre-qualified them. So this depository shall be accessible by the public for viewing. All the information that is supplied by the supplier and contractor, they are responsible for ensuring its accuracy. But that does not mean to say that you, as the public body, would not take the necessary care and attention to make sure that they have put in the information and it's accurate. And when you are doing your due diligence, you are guided by Section 29(1)(e), that the supplier and contractor, you can call upon them at any point in time to confirm the accuracy of the information supplied. And if they have misrepresented it, you can take the necessary steps to rectify it. So what is pre-qualification? Is the procedure to identify before solicitation the suppliers and contractors who are qualified to perform the goods, works, or services. And based on that, you can do then a pre-selection, which reduces the amount of persons that you want to participate, or if you have sufficient, you just go ahead and invite all. So it's the is to identify prior to solicitation a limited number of suppliers or contractors who best meets the requirements and qualifications. So where you have 100 suppliers and contractors providing that goods, works, or services, you can determine on what basis, based on a clear and transparent basis, how you're going to reduce that list from, let's say, 100 to 10, 15. And you must stick to those criteria when doing your pre-selection. You can get guidance on pre-selection and pre-qualification on our website. Feel free to download it, and also the depository can be accessed, and we have given access to your named procurement officer and also to your accounting officer to access the depository. So what are some of the things you'll be looking at? 29.1 dictates some of the requirements. So the supplier and contractor must have the legal capacity to enter into the contract. They are not insolvent, in receivership, bankrupt, etc. C is one that we would have changed based on interaction with the government, and we thought it was not fair. You'll see it in red, that they have not, and their directors or officers have not been convicted of any criminal offense. That is very, very wide, and it includes a lot of criminal offenses that really are not procurement related. And we thought it was unfair to keep people who would have been made restitution and so on back, keep them away from procurement activities. So we went to the government and said, we think it should be changed, and this is what we agreed on the change, and this is now changed under Act 27 of 2020. They have not been convicted within the past 10 years of corruption or fraud-related offenses locally or internationally as an individual or as a director or officer of a company. Continuing, they must have fulfilled the obligation to pay all required taxes and contributions, NIS, etc. in Trinidad and Tobago. They must have the necessary professional and technical qualification, competencies, etc. And they must meet relevant industry standards. For example, if you have to work on a live plant in Point Lisas, you have to be store certified to work in heritage, NGC, and so on. So those are the requirements. Also in the construction industry, you'll be looking at HSSE performance and so on. Any requirements established pursuant to this section shall be set out in the pre-qualification or pre-selection documents, if any, very importantly, and in the solicitation documents, and shall apply equally to all supplier or contractors. So there must be equality of treatment. So you don't decide you will pre-qualify one contractor and then not pre-qualify another, which we have been told happened in the past, where you have a lot of persons making application for pre-qualification and they are just basically ignored. For the first time now, under the new Act, there is what is referred to as a standstill period. And a standstill period is a period from the dispatch of a notice as required under Section 35(2), during which a procuring entity cannot accept the successful submission and the supplier contractor can challenge the decision so notified. So what happens, how it works? It's a period of 10 to 15 days whereby when you go out for your request for proposal, you state clearly that a standstill period will be observed. And the period of standstill observation will be between 10 and 15 days. So you state 10 days or you state 15 days or 12 days or whatever it is. When you have gone through the process, you have gathered all the tenders, all the bids have come in, you resolve all the issues through addendums and so on. And you have evaluated it and you have come to the position, gone through all your internal proceedings, right up to the named procurement officer, accounting officer, board for no objection. And you're about to award, you have to now notify all the participants that you will be awarding the contract to contractor A at price B and that the standstill period have started to run. If no supplier contractor makes any request for clarification or objections, you award the contract at the end of the standstill period and there was no opportunity for a review after that. If, however, a supplier contractor asks for a review, you are obligated now to give them the relevant answers. You have to keep your files really up to date. Tell them why they would not be chosen. If they are satisfied, no further action. If they are dissatisfied with your explanation and you cannot resolve it, they can then come before the standstill period has expired and ask for a challenge of the process to the OPR. So that's how the standstill period works. I'll switch now to give you some highlights in terms of disposal from the Act. A definition for disposal relates to any transfer without value, sale, lease, concession, or other alienation of property that is owned by a public body. So anything, whether you give it to another organization, you give it to a charity, it is a disposal and it falls under the Act. So there are certain procedures that you have to follow now. Public procurement, public property means real or personal property owned by a public body. So real property is things like land, building, the affixation next to the on the land and building and so on. The regulations associated with that is still to be developed by the Minister of Finance under 57A of the amended Public Procurement and Disposal of Public Property Act. Of course, the public body shall comply with such general guidelines, etc., and such special guidelines, which I would have mentioned before, that are required to either be adopted based on our handbooks and guidelines or the ones that you would have prepared. Challenge proceedings, as I mentioned when I just discussed the standstill period, is really limited to very specific cases. And I'll go through these very briefly. So any supplier contractor can bring a challenge proceedings where it is alleged, not yet proven, just an allegation, that the procuring entity made a decision or took an action that is not in compliance with the Act, and the supplier or contractor has suffered or is likely to suffer loss or injury because of the decision or action. So it must be twofold. And they can bring that challenge to the office for review of a decision or the action in keeping with Section 51. Once they do that, it must be in writing within the following time period. So I mentioned solicitation, pre-qualification, and pre-selection. So before the bid is actually received, you can make an application for a review on the basis of pre-qualification, pre-selection, solicitation, before the submission and deadline for presenting the bids. Under B, you can also make an application where within the standstill period that I would have mentioned. And if there are no standstill period that has been applied within 7 working days after the publication of the notice of the decision or action that is taken in accordance with the Act. So you have 3 cases where you can make those applications. 1 for solicitation, pre-qualification, and pre-selection. 2 under the standstill, and 3 where no standstill period within 7 working days after the publication. So within 3 days of the office receiving the application, we will publish a notice in at least 2 daily newspapers of that fact. And within 3 days of the receipt of the application, based on the application itself, and once we have reviewed it and we do have a team ready and able to review that, we can order the suspension of the procurement proceedings at any time before the entry into the force of the procurement contract. That's under 1 and 2. Or order the suspension of the performance of procurement contract or the operation of a framework agreement that has entered into force if and for as long as we find it necessary to protect the interests of the applicant. Quickly going through now for ineligibility, and in some forum you will hear the term blacklisting. So there is a process now to make suppliers and contractors and officers, directors ineligible from doing business with public bodies. Suffice it to say that going forward, there will only be one list of pre-qualified contractors. Under regulations, you are now mandated under regulations to only use the list that will be established by the office of which you will be a party to establishing that. So you don't have your own list of pre-qualified contractors and suppliers. They must all be pre-qualified. So if you haven't started that process, it's a good time to start that. If the supplier and contractor misbehaves, they can be added to the ineligibility list for 3 reasons. And that list will be published to all public bodies. 1, if they consistently fail to provide satisfactory performance, they can be debarred or be put on the ineligibility list for a period of up to 10 years. A period of up to 10 years. If they are found to be indulging in corrupt or fraudulent practices, for 10 years. If they are convicted of an offense under the Act, for 10 years. Of course, they'll be accorded an adequate opportunity to be heard by the office and make representation before they are added. So you have to keep very good records to make sure that A is enforceable based on evidence. So if you don't have evidence and you make the application to the office, most likely we would not entertain it. So you must have good evidence for it. Who will be made ineligible? The supplier contractor, directors, managers, senior officers, etc., etc. And they can't come back after they have been delisted or ineligible and operate another new company or be participating in a different company or set up a new organization. Once we find out, they also will be delisted for the period of ineligibility. So recapping some of the specific impact on the Act on the public bodies, we will now have the removal of the CTB, and you have to carry out all your procurement and disposal activities on your own. You must have a named procurement officer. You must establish a disposal committee and a PDAC. You have to develop the annual procurement plan and the list of procurement activities. You must either adopt our handbooks and guidelines or prepare your own for approval. And you have to implement the necessary internal controls. So for example, you don't have your finance department involved in the procurement activities, creating a conflict of interest. So under the Act, there are several offenses and penalties that are listed. And I would have mentioned when I mentioned the appointment of the named procurement officer and the commission of the offense and who is responsible. So if you fail to comply with the direction of the OPR, you can be charged $100,000 for each occurrence. Failure of a member of the board of the OPR or a committee constituted by the board not to declare an interest during an active investigation or hearings, $500,000 and 1 year in prison. It's very important that you understand it's a fine and a penalty of a custodial sentence. $500,000 and 1 year. Splitting of procurement, $500,000 1 year. Failure for procurement entity to comply with requirement with respect to confidentiality of information. Same thing. If you victimize persons for reporting bad practices, $500,000 1 year. Failure for person to report instances of collusion. If you are aware of collusion taking place and you fail to report it as a public officer, $500,000 1 year. Any false report to the office once proven, $500,000 1 year. If you conceal or destroy information required for an investigation, you must keep all your information for investigation purposes. Excuse that it was lost in a car and the engineer was in front of Gulf City and somebody breaking the car, you must make sure that those things are properly secured and you have more than 1 copies of the truth. So you are allowed to have electronic versions and so on. Failure on this score is $5 million and 10 years in prison. Failure to comply with requirements with respect to confidentiality in a challenge proceedings, 500,000 and 1 year. Conduct influencing public officers. So this is not only about the named procurement officer or the accounting officer. Any public officer found to be involved in bribery, conflict of interest, corrupt, fraudulent, collusive, or cohesive, or obstructive practices. So that if you try to get your own way in terms of influencing the outcome, 1 million and 5 years imprisonment. Involving bid rigging, 5 million and 10 years imprisonment. And if you alter a document to influence the outcome of the proceedings, 2 million and 7 years. And any contravention of the regulations made by the minister on the advice and recommendation of the OPR, up to $1 million and 5 years imprisonment. And I hope you like the little cartoon underneath there. If you are involved in the dollars, you will end up with your 2 hands behind your back, and that could lead to significant amount of tears. So what are some of the amendments under the Act that recently was passed? There were 3 amendments actually. In 2016, Act 5 of 2016, it provided for the establishment of the Procurement Review Board. So if you are dissatisfied with the outcome of the proceedings at the OPR, you can take it to the review board, which is headed by a retired judge. 2017, Act 3 of 2017 reduces the term of office of the regulator. Previously, it used to be 7 years. It has now been reduced to 5 years. And the other board members now, they have stints of 4 years and 3 years. Previously, I believe it was 5 and 4 years. And the amendment 2020, Act 27 of 2020, which I mentioned, it made some changes to Section 7 of the Act, and it also excludes certain things from being under the Act, like legal services, accounting and auditing services, emergency medical services, etc. So we did go to the government and ask for a review of the definition of bid rigging. Previously, based on information that we would have received, it was suggested that the definition of bid rigging was not sufficient to constitute an offense. So therefore, that was changed. Section 7 actually was amended. Disposal of public property, the third schedule, the third feature of disposal of public property under the Section 13O that we are no longer responsible for. The due diligence in terms of criminal offenses, the time of decision review of the review of action by the entity. We previously had 20 days in which to give a written response. That has been extended to 30 days, working days. And conduct influencing public officers and their affiliates, and also options available to public officers. All those were reviewed. Additionally, you would see now these details. So what constitutes bid rigging? Collusion between parties for the purpose of manipulating the proceedings. That was what was there before, and it is changed to collusive price fixing and anti-competitive behavior, which is designed to unfairly influence the outcome of compliance or competitive tender process, in favor of one or more bidders. So it's a little bit more detailed, and we looked at international best practice in terms of definitions and so on. So under Section 7.2, previously, this was how it was written. To the extent that the Act conflicts with an obligation of the state under arising of the following: a treaty or other form of agreement, an agreement entered into by government of Trinidad and Tobago with an international financial institution, an agreement for technical or other cooperation between the government and the government of a foreign state. It says that the requirements of the treaty or agreement shall prevail. Previously in red, it read, except that the procurement of goods, works, or services shall be governed by the Act. and shall promote the socio-economic. So that piece has been now taken out of the Act, and it stops at shall prevail. However, under 3, a procurement entity in a procuring entity engaged in procurement proceedings relating to a treaty or agreement referred to in subsection 2A above shall comply with section 29, which I would have gone over with you, and submit a report of such compliance to the office. So it's not a free escape. And of course, once that report comes to us, we will then send it to Parliament, the Speaker of the House. Section 3, or Section 7.3 says that the procuring entity engaged in procurement proceeding related to a treaty or agreement referred to in subsection 2A shall comply with section 29. It does not apply to matters related to national security. So where there is national security concerns, that is not reportable. And I mentioned the exemptions for legal services, debt financing services, accounting and auditing, medical emergency, or any such other services that the minister from time to time may make an order to determine. However, it's not again free for all. The minister has to submit to the office annual guidelines within which those exemptions is operated and the circumstances under which the exempt services may be procured. So those have to still be written by the Minister of Finance. Disposal of public property. I mentioned the exemption. The office no longer requires to deal with under 13.10. And we would have made the recommendation for the change under 29C. I would have gone through that already. And we would have gone and asked for a 30-day period to give our written decisions, and that has moved from 20 days to 30 days. Relative now is defined to include common law relationships. So that's one of the things that we included in the amendment. For the purpose of subsection 1, relative means a spouse, cohabitant within the meaning of the Cohabitational Relationship Act, father, mother, brother, sister, son, or daughter. So those are conflicts of interest. There are 10 sets of regulations that was passed in the lower house on 14 January 2022 and the upper house on 8 February 2022. It's very easy reading, but it's very important reading that you get your hands around those regulations, because it gives you a lot of details as to how you actually go about operationalizing the Act. So feel free to download those and have a look at them. It really is very good reading. I wouldn't go through in detail, but just summarize. Under the participating in Procurement Regulation 2021, it deals with domestic preference, margin of domestic preference, participation of joint ventures and other consortia, and Procurement Depository. So now you can give preferential treatment to domestic suppliers and contractors over foreign. They have a 10% preference rate that you can use when evaluation is being done under certain circumstances where it is clearly defined in this part of the regulations. And then you have pre-qualification and pre-selection. It deals with clarification of pre-qualification documents, invitation for pre-selection, assessment for pre-selection, and pre-selection scoring criteria. So it gives you a nice synopsis of what you can do to reduce the numbers from 100 to 10 that, as I mentioned in my previous slides. Procurement and methods deals with strategic procurement, thresholds, open bidding, limited bidding, request for quotation, procedures for single source, framework agreements, electronic reverse auction, and procurement and disposal advisory committee and technical specification. this is probably the biggest set of regulations, but the most important one in terms of the types of open bidding, limited bidding, and different types of procurement activities. We have gotten a lot of questions in terms of single source, sole source, when you can do it, when you can't do it, and so on. All that is contained here. The guidelines is clearly stated under these methods. And then how we go about evaluating. The evaluation criteria, the price factors you have to use, non-price factors, and how is the standstill period embedded in these procedures. The details about the 10 and 15 days and so on, how you go about observing that, that is under evaluation regulations. Procurement of consultants, which is a big one for a number of organizations, and it might also be for your organization. How do you deal with submission of proposal, evaluation, procedures, and so on, unsolicited bids and so on? You will get some of those coming through. And then records of proceedings, very important. You don't want to face a fine of 5 million and 10 years in prison. So the requirements to keep records, the contents of the records, and the reporting of according to the Act. And then we go on to retention of public property and disposal of personal property. We have not developed the one for real property as yet. So risk-based approach to retention of public property and disposal specifically to the employees of an organization. So if you want to dispose to employees in your organization from board come down, nothing stops it, but you must follow the regulations in terms of what is required. And then the whole different procedures under the challenge proceedings that I mentioned is encapsulated in the challenge proceedings regulations. And then the ineligibility, I would have mentioned that one also, how we go about with the hearings and evidence, the sanctions, and how you execute on the ineligible proceedings. And then the miscellaneous regulations that deals with if we have to constitute committee members under Section 16 of the Act. There are requirements under the regulations as to the fit and proper requirements. So that brings us to the end of my section, and I'll hand over to Maurissa, but I've seen we have gone for about an hour and a half. So if we want to at this time, we can briefly break for a 5 minutes comfort break, and then we restart in 5 minutes time with your permission.
Good morning again to all participants. So we will resume the session. It is 9:53. So you should see the presentation coming up on your screens now. Can anyone unmute and just confirm that you are seeing the presentation on your end?
Yes, seeing on our end.
Yes, we are seeing it. Yeah.
Great. Thank you so much. So I will take you through the procurement methods and procedures, the procurement process, and some points that you need to note, and developing your organizational procurement policy. So essentially, when we speak of procurement methods, we're referring to the procedures through which a procuring entity, be it either public or private, purchases their services, their goods, or their works. So some procurement methods you'll see based on the discussion we'll have today are competitive, whilst others are non-competitive. So we heard Mr. Lalchan go through the highlights of the regulations, and he would have spoken to the Procurement Methods and Procedures Regulations of 2021. So I will just go a little in depth, and I will pull out the relevant regulations, the sections of the regulations that deals specifically to the procurement methods. So under open bidding, Regulation 5, Subregulation 1 states, a public body shall utilize open bidding unless the complexity of the procurement or market conditions renders another method more appropriate for achieving best value for money. So essentially, we see that open bidding is the default competitive public procurement method under the regulations for acquiring goods, works, and services. And this is because open bidding exists where there are multiple suppliers available to fulfill your requirements and they are willing to vie for your business. So we see where strong competitive factors exist in the market, your negotiating power as a public body is stronger, and therefore you have greater opportunities for gaining concession in price, as well as payment terms, your service terms, and your terms of support. So some fundamental requirements of open bidding, and these are codified in Regulation 7 of the Procurement Methods and Procedures Regulations of 2021. And they are: it must be open to all qualified and interested bidders. It must be advertised locally or internationally and regionally where required. Your bidding documents must have objective qualifications criteria contained therein. Your bidding documents must have neutral and clear technical specifications, and it must have clear and objective evaluation criteria. So limited bidding. So what is limited bidding? So basically, this is a procurement method that limits the request for tenders to a select number of suppliers or contractors. And Regulation 8 outlines the requirements for a public body who's wishing to engage in limited bidding. And Regulation 8 states, a procuring entity may engage in limited bidding to restrict the number of suppliers or contractors who are invited to make a submission where A, the subject of the procurement, by reason of its highly complex or specialized nature, is available from a limited number of suppliers or contractors, or B, the time and cost required to examine and evaluate a large number of submissions would be disproportionate to the value of the subject of the procurement. And Regulation 9 of Regulation 1 goes on to state, where a public entity wishes to engage in limited bidding, you must include a justification for the reason for selecting this particular method in your record of procurement proceedings. So two-stage bidding. A key feature of this particular procurement method is that the submission of the proposal takes place in 2 stages. And bidders can assist the public body in defining the technical requirements and the scope of work. And Regulation 6 outlines the stages for two-stage bidding procurement method. So the first stage, the bidding document shall request a supplier contractor to present an initial tender containing only his proposal, and this is without a tender price being included. So the firms are then evaluated and they're scored, and the qualifying firms are invited for discussions with the public body for the purpose of reaching an agreement on the proposed technical solution. And stage 2 of the two-stage bidding procurement method is where the public body invites all the suppliers or contractors whose initial tender was not rejected during the first phase. So they've been successful in the first stage, and they are now invited to present a final tender with a contract price included in response to the final set of terms and conditions of procurement as provided by your public body. And this particular procurement method is used to request proposals from firms where the technical requirements are very difficult to define by the public body, and it's usually of a very highly specialized and complex nature. And we go on to discuss framework agreements. A framework agreement is basically an arrangement between one or more procuring entities and one or more suppliers or contractors, which establishes the terms and the price, and even where appropriate, the quantity under which a supplier will enter into one or more contracts with your procuring entity during a specified period. So the framework agreement procedure is at the first stage, the selection of suppliers or contractors to be a party to the framework agreement with the procuring entity. And Regulation 18 states the invitation of a supplier or contractor to be a party to the framework agreement can be done utilizing either the open bidding method that we discussed before or the limited bidding method. And when you have established the contract or the framework agreement, your second stage will be where you are able to call down the required goods, works, or services from the supplier contractor based on the terms of the framework agreement that you have established. So a
Ms.
framework
Mahadir,
agreement.
we are
Yeah.
still seeing your bidding-based procurement method slide. The slides haven't moved as yet on our end. I'm not sure if it's the same for everyone else. Just so you're
Yes.
aware.
Yes, we're on this slide. We're just dealing with framework agreements, which will be the last procurement method on this slide.
Okay.
Yes. Okay, so framework agreements basically offers economies of scale through the aggregation of creating covering hundreds of items with the prices and the terms of conditions already agreed. So they're used when the need for the good, work, or service is expected to arise on an indefinite or repeated basis during a given period of time. So you can use framework agreements, for instance, for your drinking water, your stationery, your janitorial services. Or you can utilize framework agreements where the need for the good, work, or service may arise on an urgent basis, which requires immediate delivery during a given period of time. So you can use framework agreements, for instance, if you are facing a natural disaster, you know that, okay, you are prone to flooding, you are in a hurricane-prone or earthquake-prone area. So we move on to RFP-based procurement methods. And the first RFP-based procurement method is the request for proposal without negotiation. And this is a two-envelope procurement method that can be used for goods, works, or services. It is typically used when suppliers or contractors are expected to propose a specific solution via their methodology or work plan to fulfill your specific requirements. So the suppliers and contractors are required to submit technical and financial proposals, but in two separate envelopes. The technical proposal of the bidders are evaluated first, and it's ranked according to pre-established evaluation criteria. And only the financial proposals of those firms that achieve the minimum score indicated in your RFP are opened and evaluated. So selection of the successful proposal is based on what we refer to as the MEET principle, the most economically advantageous tender, taking into consideration technical, quality, and sustainable characteristics, and not solely based on price. Then we go on to the RFP with Dialogue Procurement Method, and this is also known as the best and final offer. So this particular method includes a phase during which the shortlisted proponents engage in private concurrent dialogues with evaluation committee members prior to submitting their final offer. So what this allows is for the parties to establish a more thorough understanding of the contract requirements and to explore a range of alternative proposed methods of procurement of the project performance. So this particular method is appropriate where it is not feasible for you as a public body to formulate a very detailed description of the goods, works, or services that you are in need of, and therefore you require dialogue with the suppliers and contractors to obtain the most satisfactory solution to your specific procurement need. It is also a method that is used if the contract being sought is for the purposes of research, experiment, or development, or where open bidding would have been engaged in by your particular public body, but either no bids were submitted, or the procurement activity would have been cancelled by your public body, and a determination was made that engaging in a new open bidding process or even a limited bidding method would not be likely to result in a procurement contract. And that's under the conditions where you can utilize the RFP with dialogue. And finally, we go on to discuss the RFPs with consecutive negotiations. And this is also known as your rank and run procurement method. This method is a two-envelope system where consecutive negotiations with responsive bidders are required in order to ensure that the commercial terms and conditions of the procurement are acceptable to the public body. So consideration of the commercial proposals and consecutive negotiations with the top-ranked proponents are only done after the evaluation of the technical proposals. So the consecutive negotiation RFP allows the public body to run down the rankings basically to negotiate with the next ranked proponent if negotiations with the top ranked proponent is unsuccessful. And we will briefly discuss some other procurement methods. So we start off with the RFQ, or your request for quotation. This procurement method is used for very small value procurements of readily available off-the-shelf goods, small value construction works, or small value services procurement. And Regulation 11 mandates that a procuring entity must request quotes from a minimum of 3 suppliers and contractors. And invited suppliers or contractors should be given adequate time, usually no less than 5 working days, to prepare and submit their quotations. The invitations are not complex, and this method is considered non-competitive because you as a public body, you're able to determine which suppliers or contractors you are requesting quotations from. So for this particular procurement method, the quotations are received and they should be first evaluated to determine that they are compliant with your technical and administrative requirements. Only after your technical and administrative compliance is determined, a price comparison is then made between the compliant bidders. And then you can select the lowest price quotation from the pool of compliant bidders. And that would be how you go about your request for quotation process. Single source procurement. So this is a non-competitive procurement method whereby a public body engages one supplier contractor, although other suppliers or contractors are available. And Regulation 12 provides that single source may be appropriate where the procurement represents a natural continuation of previous competitive procurement procedure, and it will be its non-competitive advantage would be obtained by the public body in engaging in another competitive process. Or the subject matter of the procurement is either a spare or replacement part for equipment that's already in use by your public body. The subject of the procurement is a good, which is similar to a good in use by the public body, and the single source procurement method would be the most cost-effective method to employ. The subject of the procurement is to be provided by a supplier contractor who is already in possession of relevant information and data, and we see this happening a lot with your security services contracts. Another public body supplies the goods, works, or services, so you can utilize the single source procurement, or in cases of emergency. And the single source procurement is basically a method where it's you're choosing one supplier contractor, although others are available in the market to provide you with the goods, works, or services that you are seeking. And this differs from sole source procurement, because sole source procurement is where only one supplier contractor is capable of providing the good, work, or service due to specific expertise or technical reasons connected with the protection of exclusive rights. So Regulation 14 states that sole source can be utilized where, due to extreme urgency brought about by unforeseen events not attributed to your public body, the subject matter of the procurement cannot be obtained in a timely manner if open or limited bidding method is utilized. So we see where source procurement is where only one supplier contractor exists, or Regulation 14 extends it a bit to say that you can utilize it, but it must be in extreme urgent circumstances that are not foreseen by your public body. And we'll discuss some factors to consider when you are selecting your procurement method. So you must consider your organization's mandates and your organization business needs, the characteristics of the items that you seek to procure, the market situation. So you will have to consider, is the market for this particular product a volatile market? Is it a stable market? Do prices change quickly, or is it something that is readily available that I can get off the shelf via purchasing? The degree to which the procurement is urgent for your particular public body, the appropriate level of technology required to carry out the procurement, the procurement method and or technique that would be most suitable for instance, as discussed before, your simple low value items that are easily obtainable. So we discussed the request for quotation method, or more specialized or complex procurement. And we went through your request for proposals. You also have your ITB and your ITT procurement methods. The capacity, that is the judgment, experience, and skill of the procurement officer to select and successfully operate complex procurement methods whilst ensuring that abuse and corruption are not introduced into the process. So you must ensure that your procurement officials have the capacity to successfully run a particular procurement method. So if they may not have experience in doing the two-stage bidding process, and that's a very complex bidding process, you may want to consider carefully whether you would want to engage in that procurement method. Now, Regulation 4 also states that the office may, by guidelines, establish different thresholds to be used for different procurement methods. And threshold values trigger an appropriate procurement method. So once a threshold value is established by the office, it will be a major factor that determines your particular procurement method. So if the office decides to establish a threshold value of $5 million, above which you must engage in an open procurement bidding method, that means that once your procurement activity is above that threshold, that is the procurement method you must select. And we will go on to discuss the procurement process and some points that you must note. So the procurement proceedings is broadly defined in Section 4 of the Act as including the following 4 stages. So step 1 would be a planning stage. Step 2, solicitation of tenders. Step 3, awarding of contracts. And step 4, contract management to close out. And I will go through each stage individually in the upcoming slides. So let's start with stage 1, step 1, which is your planning stage. So proper procurement planning, it supports transparency and accountability within your procurement function. It enables your procurement to be carried out in a strategic, systematic, and procedurally accurate way. So basically, in a nutshell, planning is the process of deciding what to buy, when to buy it, and from what source. And a critical first step in your procurement proceedings. So it not only allows you to be compliant with the Act, because the Act now requires that you have stage 1 as your planning, but it also ensures a public body achieves value for money. So to achieve the objects of the Act, each public body is required to perform their public procurement functions at 2 levels. So the first level would be the strategic level, and activities at the strategic level set out the overall direction for your procurement in alignment with the strategies outlined in your strategic objectives. And the output for this particular level of planning is your annual procurement plan. And we would have heard Mr. Lalchan speak about that requirement and your annual schedule of planned procurement activities. At the operational level, which is level 2, your outputs ought to be your procurement strategy development form, your procurement details, your evaluation criteria, your evaluation methodology, and your contract management strategies. So all public bodies are required to conduct an annual procurement planning activity exercise at the beginning of your budget estimate process. So the process of preparing the APP is spearheaded by your named procurement officer in collaboration with your budget holder. So the APP must be approved by the accounting officer and is transmitted to the office for review and our noting. The annual procurement plan, it represents a strategy through which your public body can manage your procurement-related risk and opportunities in support of your delivery of your organizational mandate and strategy. Framing the annual procurement plan involves identifying the links between procurement and your program goals and objectives, and is based on a review of your mandate and strategy and an analysis of your procurement portfolio, your function, and your internal capacity. So the APP provides the logic for how you allocate your scarce resources to your overall procurement efforts. It would also help you identify the aspects of procurement improvements and associated performance measured required for supporting your business goals and your objectives. So the APP will cover a 12-month period and will, firstly, identify all items to be procured for the upcoming fiscal. A good starting point for you to determine the items that you require to procure during the fiscal would be looking at your strategic plan. You can look at your business plan. You can look at your annual estimate of recurrent expenditure and your developmental programs, your individual department plans and project plans and other project proposals. And secondly, analyzing the items that you wish to procure include an analysis of the nature of the supply market, probability of supply failure, so you have to look at your risk, the strategic importance of the particular item. Is it high on your agenda that you have to procure? Will it affect how your organization's performance or operates? The impact on you as a public body if the supply is to fail or you don't get the product in time, and how the goods, works, or services will be procured, and who do you wish to procure your goods, works, or services from. So an analysis of the items will assist with determining the most appropriate procurement strategy. And your procurement strategy basically outlines how you as a public body ensure how the goods, works, or services you seek from the relevant supply market represent value for money and that they are fit for purpose to support your business goals and objectives. Your procurement method, and we discussed those before, it helps you identify the procedure through which you will employ to procure each item that you have identified in your annual procurement plan, and also outline your contract management strategy. And basically, your contract management strategy is used to ensure that the procurement activities are undertaken consistently to high standards, both economically and efficiently. And it will include, for instance, your delivery management system, which is a checklist that assists you in accepting, managing, and tracking your delivery orders. Supplier relationship management, that's how you track your POs, you ensure the timely payment to your suppliers and contractors. And we know that is very important, because if a supplier contractor says they are pulling out because of non-payment, that could significantly affect your operations. and contract administration, which is monitoring the contract performance from the contract initiation, which is the signing of the contract, to close out. And we will delve briefly into section 27 of the legislation. I know Mr. Lalchan spoke to this section, but this is important when you are going through your annual procurement planning process, because section 27 states, a procuring entity shall, no later than 6 weeks after approval of the national budget, publish on your website or any other electronic format information regarding all planned procurement activities for the following 12 months. Now note, your annual procurement plan is not your schedule of planned procurement activities. The schedule that is being mentioned here to be published flows from your annual procurement plan, and it will be the document that you will publish on your website. And we will go through what your schedule must contain. And you will see a diagram here where there are key components to the annual schedule of planned procurement activity. So we're starting from the left, go to the right. So the first will be your project number. And this is an internal reference number that is assigned to the specific procurement project. Then your project name, which will be the title of your project. Then the United Nations Standards Products and Services Code. You would have heard Mr. Lalchan mention UNSPSC code. And this is how the classification of goods, works, and services is done on the OPR's Procurement Depository. So under the UNSPSC code level 3 that you're seeing illustrated here, this code represents the code for desktop laptops, which is the procurement activity we've used as an example for you here. Then you go on to give a brief description of your procurement activity, which is for the illustrative purposes, supply and delivery of 80 laptops and desktops. Then the proposed date for issuance of the bidding documents, the expected delivery or completion date, the estimated project duration for the works or services or the particular procurement activity, the procurement method that you would be employing, so it could be open bidding, limited bidding, the standstill period if applicable, and Mr. Lalchan would have spoken to what the standstill period is. So we have the minimum being 10 days, the maximum being 15 days as set out in the regulations, and the contract type. So note here that the schedule that you will be publishing on your website has no price estimate for the proposed procurement activities that you have identified. Your price estimates will go in your annual procurement plan, not your schedule of planned procurement activities. Now, publishing your schedule on your website does not constitute a solicitation, nor does it oblige you as a procuring entity to issue a solicitation document or confer any rights or any suppliers or contractors, and this is specified in section 27(3) of the Act. So we go on to speak to what is a procurement strategy. So basically, your strategy is a detailed plan for ensuring the timely supply of goods, works, or services, and the strategy is critical to your organization's ability to meet its core business objectives, and it should ideally be aligned with your organizational corporate procurement strategy. So the strategy identifies the best way to satisfy the needs of your end user, who is your requisitioning or requesting department, by obtaining the most advantageous pricing and contractual conditions through a competitive process. And what are some things that you would consider or you need to consider when you're developing your procurement strategy? The results of market research and an analysis of the requirements that contain in the purchase requisition, your organization's procurement policies and procedures, which are your approved handbooks and guidelines. And we know that your handbooks and guidelines must be approved by the Office of Procurement Regulation, the delegations of authority, and your financial thresholds, as well as any internal clearance or approval procedures and your corresponding administrative timeframes. Also, whether there are any arrangements already in place for the same or significantly similar requirements in your organization. And part of your operational procurement planning must include your demand analysis, your stakeholder analysis, your market analysis, your procurement strategy options, your preferred procurement strategy recommendations, and any implementation plans that you have within your organization. And we go into developing your requirements. So what are requirements? So requirements are the exact statements that's used by public bodies to communicate your particular need to be satisfied or the essential characteristics that you require in a good or from a service which the contractor or supplier must deliver to you. The requirements are detailed in your purchase requisitions, which are usually raised by your user departments, and they form part of your procurement contract documentation and play an instrumental role in your procurement process. So your requirements can take the form of specifications, which are used for goods or equipment, terms of reference, or TRRs as we call them, which are used for your services, and statements of works, which are used for your works. And in your specifications, you must include what is needed, why it is needed, and that's the purpose, when it is needed, and that's your delivery period, where the need must be delivered, and any quality standards or KPIs. So there are commonly 3 different types of specifications, and we go through each individually. So the functional specifications. So those specifications outlines the proposed function or role of the good or service in helping the end user achieve its desired outcome. So it usually defines the desired results and may describe the general form of the goods or the works being required. The performance specifications. These details the required performance characteristics of the good or service. It focuses on detailing the desired output of the good or service and not how it is to be achieved. So for instance, you may state that you want a particular piece of equipment to be operational for a minimum number of hours in any specific time period. So that's how you would develop your performance based specifications. And technical specifications. So these detail the technical and physical aspects of the goods or services, such as its dimensions, its design, and its physical properties. Technical specs are used when the functional or performance characteristics are insufficient to define the requirements. You can also utilize diagrams and dimensions in your technical specifications as technical characteristics or to provide some guidance to your suppliers or contractors. So technical specifications are very specific. If you are utilizing technical specifications, it means that you know exactly what you want, exactly how you want it. So functional and performance specifications allows the suppliers and contractors to offer more innovative and technologically advanced solutions that can improve your value for money outcomes. Your technical specifications, what you ask for in your bidding document, if you're using that type of specification, is what you will get. So some key points to note when you're developing your specifications. Your language should be clear and as simple as possible. Do not over-specify or under-specify your requirements. And third, but definitely not least, avoid using brand names or brand-specific references because this can drive up price, and a brand name does not always equate to quality. So let us move into solicitation of tenders, which is stage 2 of the procurement proceedings as defined by the legislation. So these are some types of solicitation documents. So your request for quotation, we would have seen that we mentioned it under your procurement methods. It's a method and it is also a solicitation document. And as previously mentioned, they're used for small value procurement of readily off-the-shelf goods or small value services. So this type of solicitation document is used in a limited bidding or non-competitive procurement method because, as mentioned before, you determine which suppliers or contractors you send your RFQ to once. According to the regulations, it must be a minimum of 3. Your request for proposal. So we saw we had many different procurement methods that utilize the request for proposal document. So these are used when the requirements cannot be fully defined and or quantified at the time of the solicitation, and where you require innovation or expertise from the supplier contractor, and that it informs the requirements of how your needs are being met. Your invitation to bid, sometimes you may hear persons refer to it as the invitation to tender or ITT. So if you're utilizing this solicitation document, the procuring entity is able to define your detailed requirements to which suppliers or contractors respond to by offering bids or tenders. And you usually see your ITB or your ITT go hand in hand with your technical specifications because you are certain of what you want and you can clearly define it for the suppliers or contractors. Your expression of interest. So it's used to invite potential suppliers or contractors to indicate their interest in participating in an upcoming procurement activity. So the EOI provides potential suppliers or contractors with a broad scope of services and expected timelines for execution of those services. So in response, potential suppliers or contractors express their interest and provide information in response to the request. And you will see typically an EOI can also be used in your market research phase when you're trying to get, okay, what's happening in the market, how many suppliers are there, the positioning of the suppliers within the market, and so on. And finally, your request for information documentation. It's used to obtain general information about goods, services, or providers, and it's used prior to specific requisitioning of items. So, like the EOI, the RFI can also be used as part of your market research process. And the RFI you can use to actually request information or technical developments, supply availability, or even price indicators that exist within your market. So preparation of your bidding document is the process of basically compiling information and documentation that will enable the suppliers or contractors to prepare responsive and comparable submissions that are consistent with your requirements. So your bidding document should include the nature and time frame of your procurement activity, the required qualifications of the suppliers or contractors, and the documents required to satisfy those requirements. So if you're asking persons to submit their CVs, if you're asking them to submit copies of the actual qualifications, you must specify that in your bidding document. Information on site visits and pre-bid meetings, you must include that if site visits or pre-bid meetings are required in that procurement process. Instructions for the preparation and submission of tenders, so you include your deadline for submission, where they have to submit their bids, and the time for the opening of the submissions. Also, the components, to be reflected in the price, so you indicate what currency that procurement activity is in. So if, for instance, you may have international or regional bidders, you indicate the exchange rate for the particular currency that you would have quoted, as well as all applicable taxes. The criteria and methodology for the evaluation of submissions. So you must include in your bidding documents how you intend to evaluate those suppliers or contractors that would be submitted bids, as well as the weighting for each criteria. The limitation of participation in the procurement proceedings. So Mr. Lalchan would have spoken to the option under the legislation to limit participation to pursue industry development utilizing the local content provisions in the regulations. Your grouping of goods, works, or services into lots and packages. If you have lots and packages for that particular procurement activity, it must also be specified in the bidding documents. Whether alternatives to the technical or contractual specifications would be considered. So you may state your requirements for a specific good. If you can also accept alternatives, you will also note that in brackets in the bidding documents. The required validity period of the bids, the number and acceptable form of submissions, performance, or other security. If you need a performance bond, you will have to specifically state that in the bidding document, and the price of the performance bond that you require or the performance security. The terms and conditions of the contract to be awarded. So typically you will have what is considered a skeletal performance contract precedent, that's attached to your bidding documents. So some key points to note when you are in the solicitation process. So the solicitation document should define the evaluation process in summary form and specify the categories on which bids or proposals will be evaluated, indicating the weight assigned to each. So if you're doing qualifications, that must be a criteria that you set out. And if you have sub-criteria that is relevant that you would be utilizing to score, then you will have to also identify those sub-criteria. Explain the criteria that can or will result in a rejection of an offer, and state the relative importance of each major evaluation criteria. So if you have a condition under which a bid will be rejected, you must specifically state that in your bidding document so suppliers and contractors are clear. Specify the evaluation criteria, sub-criteria, your scoring system and methodology to guide the bidder in the preparation of its bid or its proposal. So we see sometimes that in bidding documents you will have a supplier contractor must achieve 50% in each criteria and 70% overall. If that is your methodology, then that must be included in your bidding document as well. And create a level playing field. So all potential suppliers or contractors must receive the same information at the same time. The solicitation document should be issued and distributed simultaneously to all suppliers or contractors, either by mail, courier, email, or be made available electronically on the internet in the case of an open tender. If they have to purchase bidding documents, it must be readily available for them at the same place so all suppliers and contractors can access it or purchase it. So we go into stage 3, which is the awarding of contracts. So the procurement department is expected to take the lead in evaluating competitive offers and assisting in selecting the supplier for any particular contract. So the methods used for selection of a successful supplier contractor are some of the most important elements of the named procurement officer's skill set. So before selecting an offer, every public body must employ an evaluation process to ensure adequate consideration of all aspects of the public body's needs are being optimized. Evaluating a supplier's offer means not only evaluating its bid or proposal from a cost perspective, but also evaluating the supplier's ability to perform to the required level of quality and speed. The need for evaluation process is twofold. So firstly, it offers all potential bidders a fair and equitable method for having their proposal reviewed, and Mr. Lalchan would have gone through the objects of the Act, and we note that fairness must take place and it must be equitable as well, your process. And it also considers a potential solution. Now, secondly, it also provides the evaluation committee with a clear and concise method for identifying the competent tenders and ultimately the best overall bid. So a procuring entity shall select a successful submission based on the evaluation criteria and methodology specified in its bidding document. If you specify a certain criteria or methodology, that is what must be utilized by the evaluation team to come to who has been successful in that procurement activity. A procuring entity's evaluation criteria and methodology shall be appropriate to the type, nature, market conditions, and complexity of the goods, works, or services you are attempting to procure, and this is codified in Regulation 3, Subregulation 2. So we go into selecting an evaluation committee. So typically, the evaluation committee should comprise of 3 to 6 persons. Someone who has the technical knowledge of the subject matter that you are procuring, someone that has the technical know-how of the applicable laws, someone that has the technical and practical know-how of the procurement process, someone with commercial acumen, and someone who knows in-house technology. So those are very important areas or components to ensure that exist on your evaluation committee when you are selecting your members. So let's talk about seeking clarification during the preliminary evaluation. So often when you're evaluating a bid, an answer may be unclear or an evaluator may feel that you need further information to enable you to evaluate the response before you properly. So in this situation, the public body must ensure that it is being fair and it is treating all bidders equally in the way you seek to clarify these matters. So during the evaluation of submissions deemed compliant, the procuring entity may seek clarification in writing from any bidder to facilitate your evaluation process. However, you shall neither ask nor permit any bidder to change the price or any other aspect of his bid when he or she is providing the requested clarification. And you shall reject any bidder and forfeit its bid security if the bidder attempts to amend its bid in any manner. And we'll just go through some typical contents of the evaluation report. So you have received the bid, you've opened the bid, you've evaluated the bid, you've deemed who has been compliant, and you have come out with a recommendation as it pertains to who is the successful contractor or supplier. So the typical contents of your evaluation report should include your introduction. An introduction to your organization and your organization responsibilities, background, and the background will be on a particular procurement activity that you're engaged in. Your process for evaluation of bid, it goes straight from your opening to your evaluation process, including all of your scoring for each individual member. Or if you have consensus scoring, you also include that. If any member of the evaluation committee objects to a particular recommendation, that must also be included in your evaluation of bids process. And then finally, you must include your recommendation for the award of contract, and of course, why you have recommended this particular supplier contractor for that procurement process. So the evaluation report is then signed by all members of the evaluation committee, and it's approved by your designated person. So it must be approved by your named procurement officer, before it goes to your accounting officer. And we know that if it's high value, high risk procurement activity, it must go through PDAC before it goes to your accounting officer. And Mr. Lalchan would have shown you that diagram. Approval of the evaluation report. So as I stated before, your low risk and low value procurements would be approved, reviewed and approved by your procurement officer. For high risk and high value procurement activities, it must go through PDAC, which is your Procurement and Disposal Advisory Committee, prior to it being submitted to your accounting officer for approval, and of course, for your board for noting objection or no objection. So the award of contract, Mr. Lalchan spoke as well to the standstill period, so I will just briefly go through. So the Act defines the standstill period as a period from dispatch of your notice as required by Section 35(2). That is your notice of your intention to accept the successful bidder, during which the procuring entity cannot accept the successful submission and suppliers or contractors can challenge the decision so notified. So you must issue your notice of intention to award to all bidders. In your notice of intention to award, you will specify the applicable standstill period. And Regulation 7 states, a procuring entity shall set a standstill period not less than 10 working days, but not more than 15 working days. So between 10 to 15 working days is what you will specify in your notice of intention to award. During that period, you cannot accept the successful submission. It gives suppliers and contractors the opportunity to challenge the decision. Upon fulfillment of the requirements of the standstill period, where applicable, the notice of award can then be given to the successful bidder. So once the time period has elapsed and you have not gotten any notification of a challenge, you can then proceed to award to the successful bidder. And just some key points to note in evaluation. The contract award decision must be objective and based on disclosed criteria. The decision-making process must be fair, transparent, and auditable. And the public body should demonstrate best value in the tendering process. So let us discuss stage 4, which is your contract management to close out phase of the procurement proceedings. So contract management involves all activities related to the monitoring of suppliers or contractors' performance in fulfillment of their contractual obligations and to ensure appropriate actions are taken to promptly remedy any deficiencies observed in the contract implementation scope or terms and conditions. So contract management, it ensures that all parties fully meet their respective obligations. It protects the parties and ensures that the required performance standards are met, as well as it allows for contract monitoring for control over variations and dispute resolution. So contract management begins with developing your contract management plan, which must contain all pertinent information about how the contract is to be managed and identifies and addresses all relevant issues throughout the life of the contract. It also must indicate or identify a delegated contract manager, or if you have a team of qualified individuals who will be responsible for administering the contract, perform the obligations and duties of the public body, which will be specified in the contract, as well as to ensure the supplier contractor implements the contract in accordance with its terms and conditions. So your contract manager or your contract management team is very, very important to the success of your contract management process. Appraise the supplier contractor's service delivery and performance of the contract to ensure that the contract terms and conditions, the technical and quality standards are met. Now, this is important since you heard Mr. Lalchan speak to the ineligibility listing now, and that is established by section 58(2), which states that one of the areas under which a supplier contractor could be put on the ineligibility list is due to consistent failure to perform or to provide satisfactory performance. So you must ensure that you do your supplier contractor performance appraisals. That is very important. You must also maintain a contract management file with all the relevant documents for the contract management process and establish KPIs, which are your key performance indicators. These are specific time-based, attainable, measurable goals that details the success of its components and how they relate to the overall contract objectives. So KPIs for suppliers and contractors must be reported on a periodic basis and forms part of the supplier contractor's performance appraisal. And we will go into now the final portion of the presentation, which is developing an organizational procurement policy. So the comprehensive handbook, so the comprehensive handbook has been developed by the OPR, and it incorporates all elements of procurement, retention, and disposal of public property in summary format, and references the relevant general guidelines in relation to specific topics. So Mr. Lalchan would have indicated we have a number of guidelines already on the website, and each guideline relates to a specific topic or a specific area of procurement, retention, or disposal. Now, the comprehensive handbook serves as the base document for developing your internal policy. So this is a document you can utilize when you are developing your special handbooks and guidelines. As Mr. Lalchan indicated, you also have the option of adopting the OPR's handbooks and guidelines as is. So we will discuss some key aspects to include when developing your organizational procurement policy. So firstly, the introduction. So this will set the context and the background on the organization, the purpose of the policy, and this will set out the standards and define the procedure for procurement in the organization, noting the legislative and operational framework, roles and responsibilities of the procurement stakeholders. For example, you will state specifically what is the procurement department responsible for in the procurement process, what is the requisitioning or user department responsible for in the procurement process, and example, what is the finance department responsible for in the procurement process. Then you go on to the organizational structure for procurement. So starting with your buyer shopper, if you have those positions in your organization, your junior procurement officers, your contract officer, your administrative officer, your NPO, who will be your members of PDAP, and your accounting officer. So the organizational structure for procurement is dependent on the size of the organization, as well as the level and value of the procurement activities that you are typically engaged in. Then we go on to the delegated level of authority. So who has the delegation responsibility for executing certain pertinent documents in the procurement process? And this will also include your financial delegation of authority, your code of conduct, which will establish the values and principles enshrined in Section 5 of the Act and lays out your company's principles, standards, moral and ethical expectations of your employees, as well as third parties when they are interacting with your organization. And it must also include the segregation of duties in the procurement process. So this is an internal control with tasks separated between different departments in order to reduce the likelihood of fraud and or error. And we have at the strategic level, You will have your annual procurement planning process. You will outline how that process will go in your policy document. And then at the operational level, you will also speak to the solicitation of tenders, the awarding of contracts, contract management. You would include your procedures for emergency procurement, whether you will utilize the framework agreement, whether in emergency procurement, what constitutes emergency procurement must be in line with the legislation, the act, as well as the method of procurement that you would utilize during the emergency procurement, variations on how they are to be treated with, forms and templates to be utilized at various stages of the procurement process. And a good thing to note here, it's good practice to develop a process map, and that will assist in developing or guiding you when you develop your internal procurement policy. So let's speak to the importance of policies and procedures. So your policies and procedures is a critical document. It establishes your core procurement policy and the standard and defines the procedures your staff needs to follow consistently to ensure effective and compliant procurement practices exist within your organization. So your procurement policy document outlines the overarching principles and standards used to set the direction and influence decisions. It guides employee decision-making under a given set of circumstances within the framework of objectives and goals of your organization. So for example, if we use regulation for one of the procurement methods regulation, where either the office may, by guidelines, establish different thresholds to be used for different procurement methods, or a procuring entity may establish specific threshold values in its special guidelines and handbooks. So, if pursuant to Regulation 4.2, the Children's Authority wishes to establish a threshold which must be approved by the OPR, your special guidelines and handbooks must state something like any procurement over a certain dollar value must be competitively bid through an open bidding procurement method. So that will be your policy. Your procurement procedures, which will be also included in your special guidelines and handbooks, will define the how your policy will be implemented. So your procedures will spell out the series of steps your employees must follow to ensure that the goal is accomplished. So using our example above, a set of procedures would need to be developed to implement the policy on thresholds. So if Children's Authority were to procure consulting services that were expected to exceed the dollar value threshold that you would have stated in your special guidelines and handbooks and would have been approved by the OPR, requiring you to engage in a competitive bidding process, your procedures will detail, for instance, the employee or the persons engaged in the procurement activity must create clear requirements for the goods or services that they are procuring, develop and get approval for the solicitation document, that they must create score sheets to support the proposed evaluation criteria, that they must invite pre-qualified suppliers or contractors, how they are to distribute the bidding documents, how they are to respond to vendor questions before closing, etc. So we see where your policy must also be backed up by your procedures, which is how you carry about implementing your policy. So consistent processes and structures. Policies and procedures keep your operations from devolving into complete chaos. When your staff is following policies and procedures, your organization will use time and resources more efficiently. You'll be able to grow and achieve your organizational goals. It also lends to a better quality service. When employees follow procedures, they perform tasks correctly and provide consistent customer service. This enhances the quality of your organization's products and services, and in turn improves your company's reputation. It also provides a safer workplace. When your staff is following policies and procedures, workplace accidents and incidents are less likely to occur, and this reduces liability of your organization and risk and limits interruptions in your operations. And we see Mr. Lalchan would have outlined the penalties relating to infringement of the Act. So your procurement policy and procedure will ensure that your employees have clear and identifiable procedures and policies by which they go about their daily tasks to ensure that they don't infringe any acts, regulations, or your approved special guidelines and handbooks. So finally, to ensure your staff follows through on compliance, your internal procurement policy must be made accessible to all staff members. So if you have an intranet, ensure that your special guidelines and handbooks are up on your intranet so employees can access them easily. Implement training on your policies. It is not satisfactory to just have a policy and put it down there. You must have periodic training to ensure that your staff is always up to date on their policies, they know the policies and procedures, and they can actually implement or work accordingly. Test the employee comprehension. So management plays a critical role in this. You must ensure that the employees that work under you know of the special guidelines and handbooks or the procurement policies and procedures, and they actually understand it. You encourage accountability. So if someone is involved in the procurement process, they must be accountable for the decision and the actions that they do during that process. And you're responsible for regularly reviewing your policies and procedures to make sure they're not outdated, to update them regularly to ensure that they're consistent with the Act, any amendments that may come to the Act, the regulations, as well as OPR's handbooks and guidelines. And we have come to the end of the presentation for the morning period.